Welcome back to The Quiet Historian. Tonight, we drift into iron judgment and the long, strange arm of medieval law. Forget the courtrooms and the barristers and the careful weighing of evidence the modern world sold you. The truth was, justice in the medieval world looked nothing like that. It looked like fire. It looked like water. It looked like a crowd in a market square, deciding together what a person deserved. Here, we do not chase the drama. We sit with the past slowly, the way it actually felt to live through. If the quiet here is the kind you have been looking for, consider leaving a like and a subscribe, not for the algorithm, for the small comfort of finding a place that matches the hour. And in the comments, leave a small note. Tell me where the night finds you, and what the room sounds like around you right now. It is good to know who else is awake. Now, lower the lights. Find a soft sound to keep you company. The hum of a fan, the slow patter of rain, the crackle of a candle, and let us settle in together. To tonight's quiet history, picture this. It is early morning, the kind of morning that arrives before the light does. A village somewhere in northern England. The year is somewhere near the year 1080. The air smells of wood smoke and wet earth and something else. Something like anticipation. The whole village is awake. They have gathered near the church, not because they want to, because they have to, because today one of their own is on trial. And the trial does not happen in a hall, or before a judge, or with lawyers making careful arguments. The trial happens here, in the open air, in front of God, because in the medieval world, God was the only judge that mattered. You are standing near the back of the crowd. You can feel the cold through your boots. The ground is half, frozen and uneven. Someone near you is holding a torch, and the smell of the pitch is sharp and close. The accused stands near the church door. They are not shackled. They do not need to be. Where would they go? The priest is speaking. His voice is low and carries in the cold air. The words are Latin. Most of the crowd does not understand them, but they understand the weight of them. That is enough. In a moment the accused will reach into a pot of boiling water, or grip a bar of iron heated red in a fire, or be lowered into a pond. And what happens next will determine everything: their guilt, their innocence, their life. This is the ordeal. And for several centuries, it was the closest thing the medieval world had to a fair trial. The remarkable thing is not that it existed. The remarkable thing is that people believed in it, completely, genuinely, with the kind of certainty that is difficult to imagine now. They believed that God would not allow an innocent person to be burned, that the water would receive the pure and reject the guilty, that the universe itself had an opinion, and that the ordeal was the instrument through which that opinion could be heard. And the real question is not whether they were right. The real question is what it felt like to stand at that church door, reaching toward the fire and trust. The ordeal, known in the Latin records as Judicium Dei Judii, CMD, meaning the judgment of God, was a legal practice used across medieval Europe from roughly the 6th century onward. It was not a fringe custom. It was not the invention of cruel men. It was a formal legal procedure, embedded in the law codes of kingdoms, endorsed by the church, administered by priests. The logic was straightforward. Human beings were fallible. Human witnesses lied. Human memory was imperfect. Evidence, as the medieval world understood it, was unreliable. But God was not fallible. God did not lie. God knew, with perfect certainty, who was guilty and who was not. The ordeal was, in essence, an invitation for God to make his verdict known through the body of the accused. If you were innocent, the thinking went, God would protect you. The iron would not burn as badly as it should. The wound would heal cleanly in 3 days. The pond would accept you into its cold water, not push you back to the surface. If you were guilty, you would be burned. The wound would fester. The water would reject you. It sounds, from where we sit, like cruelty dressed up in theology. But that is not quite right. To the people who practiced it, it was mercy. It was a system that gave the accused something no purely human court could offer. A direct appeal to a higher power. A chance that no amount of bad witnesses or hostile neighbors could take away. That is not nothing. That is, in its way, almost moving. The most common form of ordeal, in England at least, was the ordeal of the hot iron. The iron itself was a bar, roughly 3 pounds in weight. It was heated in the fire of the church until it glowed. The accused, who had been fasting for 3 days and attending Mass and receiving the sacraments, was brought before it. The priest blessed the iron. He prayed over it. He reminded God formally that this moment required his intervention. Then the accused picked up the iron and walked 9 feet. That was the measure, 9 feet. Then they put it down. Then the hand was wrapped, in cloth, in wax, sealed with the official seal of the court, and then they waited. 3 days, after 3 days, the bandage was unwrapped before witnesses. If the wound was healing cleanly, without suppuration, without the hot red swelling of infection, you were declared innocent. If the wound had festered, you were guilty. The medical reality is that nearly any burn wound, without proper treatment, has a reasonable chance of becoming infected. The medieval world did not know this, or rather, they knew that wounds sometimes healed and sometimes did not, and they chose to read that variance as divine communication. Modern historians have pointed out something interesting, though. In many recorded cases of the ordeal, the accused was acquitted. The wound healed. The hand was declared clean, which raises a quiet and somewhat uncomfortable question. Were the priests who administered the ordeal and inspected the wound sometimes inclined to see what they needed to see? Perhaps the ordeal was, in part, a performance that allowed communities to resolve disputes without anyone having to bear the full weight of the verdict alone. That is a more human story, and probably closer to the truth. The ordeal of cold water worked on a different logic, and it is the one most people have heard of, usually in the wrong context. The accused was brought to a body of water, a pond, a river, sometimes a specially constructed pit. They were bound, their right thumb tied to their left toe, their left thumb to their right toe, so that they were folded into a kind of awkward bundle. Then they were lowered in. If they sank, they were innocent. The water, blessed and holy, had accepted them. If they floated, they were guilty. The water had rejected them. You may have encountered this logic in a different setting. You may be thinking of witch trials, of ducking stools, of the much later and considerably more chaotic period of witch hunting that gripped parts of Europe in the 16th and 17th centuries. That is a different practice, a different era, and a different logic, though the surface resemblance is striking. The medieval ordeal of cold water was not, in most cases, a death sentence for the innocent. The accused was lowered on a rope. If they sank, they were pulled back up, innocent, wet, cold enough to be miserable for several days, but alive. The real punishment was the waiting, the binding, the cold, the moment of submersion, the not knowing, even as you went under, whether the rope would hold. Think of it as the world's least comfortable way of finding out your neighbors still trusted you. No thermostat involved. No appeal process either. The ordeal of hot water was, in the hierarchy of medieval unpleasantness, considered somewhat worse than the iron. Not because the burns were necessarily more severe, but because the uncertainty lasted longer. The pot was large. The water was brought to a full boil over an open fire. The accused was required to plunge their arm into the water and retrieve a stone from the bottom. For a simple accusation, the stone sat at a depth of 1 hand. For a more serious charge, the stone sat deeper, up to the elbow. This meant that the severity of your trial was calibrated to the severity of what you were accused of. A minor dispute about a stolen pig might cost you a hand, deep plunge, an accusation of serious theft or violence, or something the community found particularly troubling, cost you your whole forearm. There is a kind of terrible logic to it. The punishment was not the burn. The punishment was the calibration. The message that the community had decided, before you even stepped forward, how seriously they were taking what you were accused of. You would know, standing at the pot, exactly how much trust the room had for you, and that knowledge arrived before the water did. The priest was not a bystander. He was the machinery. Without the priest, the ordeal was nothing. It was just a man burning his hand on iron, or a person being dropped into cold water. The priest was the one who transformed the physical act into a legal and spiritual event, and the Church, for several centuries, was genuinely committed to this role. The preparation for an ordeal began 3 days before the trial itself. The accused was placed in a kind of pre-ordeal period of spiritual preparation. They fasted. They attended Mass each day. They received communion. They were, in the language of the time, being made as clean as possible before they stood before God's judgment. On the day of the ordeal, the priest blessed the instruments, the iron, or the water, or the pot. He recited specific prayers that are preserved in the historical record, prayers that asked God to reveal the truth through what was about to happen. He also, and this is the part that tends to be left out of the dramatic retellings, warned the guilty, explicitly, formally, before witnesses. The prayer over the iron, in some versions, included a direct address to the accused, something to the effect that if they were guilty, they should confess now before the iron, rather than face both the burn and the spiritual consequences of deceiving God. This mattered more than it sounds, because confession at that moment was a genuine option. The accused could step forward, admit the act, accept a lesser penalty negotiated by the community, and avoid the ordeal entirely. Many did. Historians believe that this pre-ordeal confession rate was significant, that the ordeal, in many cases, functioned as a very effective tool for producing admissions of guilt without anyone having to touch the iron at all. The priest, in other words, was not just a spiritual authority. He was a negotiator, and the fire was not just a test. It was leverage. The 3 days between the ordeal and the inspection of the wound were, by any measure, the longest 3 days in a medieval person's life. The accused returned home or to wherever they were being held. The wound was wrapped and sealed. They were not supposed to unwrap it. They were not supposed to show it to anyone. They were supposed to wait. The community waited with them. This is the part that tends to be overlooked. The ordeal was not a private event. It was a communal one. The neighbors who had gathered to watch the trial were now, for 3 days, the people who had to live alongside the accused while the verdict was still technically pending. They knew this person. They had watched them reach into the fire. They had seen the expression on their face. The verdict, when it came, was not just news. It was resolution for everyone. The inspection itself was formal. It happened before witnesses, often at the church, the same location as the ordeal. The priest unwrapped the bandage. The wound was examined. Clean healing was described in the records with a kind of careful specificity. No suppuration, no excessive swelling, flesh knitting as it should. Festering was described with equal care. The heat of infection, the smell, the unmistakable evidence that something had gone wrong inside the tissue. And then the verdict was announced, innocent, guilty, and the community exhaled. Think of it as a village-wide anxious wait for test results, except the test was conducted by a priest with a heated bar of iron, and the results were considered the direct opinion of the creator of the universe, marginally more stressful than a standard medical appointment, though the waiting room probably had better candles. Not everyone was subject to the ordeal. The medieval world had, as it had in most things, a complicated system of exemptions based on rank, status, and the particular flavor of injustice available to those with sufficient wealth. The nobility in most jurisdictions were not subject to the common ordeals. They had an alternative. Trial by combat, the idea being that God would grant victory to the righteous in a formal duel. This was, in its way, its own kind of spectacular. But it was considered a more dignified option than plunging your arm into boiling water in front of your neighbors. Clergy were also largely exempt from the lay ordeals, though they had their own ecclesiastical procedures for resolving accusations within the church. The very old and the very ill could, in some circumstances, hire a champion, someone who would undergo the ordeal on their behalf. This practice raises a question that the medieval world apparently found less troubling than we do, which is whether God's judgment, when expressed through a hired substitute, was still God's judgment. The answer, officially, was yes. The champion was understood to be an extension of the accused's spiritual condition. If the accused was innocent, God would protect the champion. If the accused was guilty, the champion would suffer for it, which seems, from the champion's perspective, like a reasonably significant professional hazard. Women, depending on the region and the century, were subject to different variations. In some areas, a woman accused of a crime could nominate her husband or a male relative to undergo the ordeal on her behalf. In others, she was subject to the same procedure as any man. The records are inconsistent. The medieval world was not, in this respect, operating from a single unified rulebook. What the exemptions reveal, more than anything, is that the ordeal was never purely about divine truth. It was also about social position, and the higher your position, the more likely it was that divine truth would be sought through a process that did not require you to be uncomfortable. Some things do not change very much. The end of the ordeal came not from a popular uprising, not from a collective decision by the communities that had practiced it for centuries. It came from a room full of bishops in Rome in the year 1215, at a gathering known as the Fourth Lateran Council. The council issued a decree. Priests were forbidden from participating in ordeals, from blessing the iron, from consecrating the water, from performing any of the rituals that gave the ordeal its legal and spiritual weight. Without the priest, the ordeal ceased to function. It did not survive the removal of its theological machinery. Within a generation, it had largely disappeared from the courts of Western Europe. The reasons the Church gave were theological. The ordeal was, in the Council's view, a form of tempting God. It presumed to demand that God intervene in human affairs on a schedule set by a local court. It placed God in the position of performing a miracle every time a village had a property dispute. This was considered, in the careful language of the decree, unseemly. There were also quieter reasons. By 1215, a number of church thinkers had begun to express discomfort with the practice. Not because they doubted God's power, but because they had noticed something troubling about the results. The outcomes of ordeals were inconsistent in ways that were difficult to explain theologically. Innocent people, by any reasonable community assessment, were sometimes found guilty. Guilty people, by equally reasonable assessment, were sometimes acquitted. If God was speaking through the ordeal, he was speaking in a voice that did not always match what the community already knew to be true. That was a problem, not a small one, and so the ordeal ended, quietly, by administrative decree. After several hundred years of boiling water and heated iron and day waits for wound inspections, the question of what came after the ordeal is, in many ways, more interesting than the ordeal itself. The answer, in England, was the jury. Not the jury as we know it now. The early jury was not a group of impartial strangers selected for their distance from the case. It was a group of neighbors, people who knew the accused, people who had, in many cases, watched the alleged act occur, or heard about it within hours of its occurrence. The early jury was essentially a formalization of community knowledge. 12 people from the neighborhood who were expected to know the truth already, and to deliver a verdict based on that knowledge. This is almost the opposite of how we think about juries today. We select jurors specifically because they do not know the accused, have not formed opinions, have not heard the evidence in advance. We treat prior knowledge as contamination. The medieval jury treated prior knowledge as the entire point. The shift from ordeal to jury was not experienced by most people as a great leap toward rationality. It was experienced as a change in procedure, one formal process replacing another. The community still gathered. A verdict was still delivered. Someone was still found guilty or innocent. What changed was where the authority came from. Before 1215, the authority came from God, expressed through the body of the accused. After 1215, it came from the community, expressed through the voices of 12 neighbors. Whether that was an improvement depended, in large part, on how your neighbors felt about you. The ordeal lasted for centuries. Through famines and plagues and the slow grinding difficulty of medieval life, communities kept returning to it, kept trusting it, kept gathering at church doors in the cold morning air to watch their neighbors reach for iron and fire. That is not stupidity, that is faith, a particular kind of faith expressed in a particular kind of world. A world without forensic evidence, without reliable witnesses, without any of the tools we now use to approach something like certainty. In that world, the ordeal was a genuine attempt to solve an impossible problem. How do you know the truth when every human instrument for finding it is flawed? They asked God, and for several hundred years, that was enough. The ordeal sits in history now as a curiosity, a strange practice, a thing to be briefly amazed by before moving on. But if you sit with it a little longer, it starts to feel less strange. Communities have always needed ways to resolve disputes, to settle accusations, to look at one of their own and deliver a verdict that everyone can live with afterward. The instruments change, the iron cools, the water is no longer blessed. But the need underneath it, the need for a process that feels, at least, like it reaches beyond ordinary human fallibility, that need has not gone anywhere. It has just changed its clothes. And somewhere in a cold morning in northern England 1,000 years ago, a person wrapped their hand in cloth and waited 3 days to find out if their neighbors still believed in them. That is worth sitting with for a moment, before we drift somewhere else entirely. Thomas the baker had been selling short loaves, not by a little, by enough that his neighbors had noticed and complained, and eventually brought the matter before the market court of a middling English town in the year 1342. The court weighed his bread. The bread was light. The verdict took less time than the weighing. And so Thomas found himself on a Tuesday morning in autumn, with his head and hands locked into a wooden frame in the middle of the market square. He would remain there until evening. The town would go about its business around him, and the town would make its feelings known. This is the pillory piaillerie, and for several centuries it was one of the most common punishments in medieval and early modern Europe. The market square is full. It always is on a Tuesday. The smell of fish and bread and animal dung and unwashed bodies mingles in the autumn air. Somewhere a pig is objecting to something, a child is crying, a cart is moving slowly through the crowd, its wheels loud on the cobblestones, and in the middle of all of it, Thomas stands bent forward, his neck resting in the curved wood of the pillory, his wrists locked on either side of his head. He cannot stand fully upright. He cannot sit. He can turn his head slightly to the left or the right. That is the full range of his world for the next several hours. The crowd knows he is there. The crowd has been told why he is there. A notice has been read aloud by the court officer, stating the crime and the sentence. In a world where most people cannot read, the spoken announcement is the public record. And now the crowd is deciding what to do with that information. The pillory was not, technically, a death sentence. It was a shaming punishment, a public correction, a way of holding a person up before their community and saying, "Look at what this person did." Look at them, but the crowd was not always gentle, and the real danger of the pillory was not the wood, or the posture, or the cold. It was the people watching, and what the crowd chose to throw was not always rotten vegetables. The pillory and the stocks are often conflated. They are not the same thing, and the difference matters. The stocks were a lower device. The offender sat on the ground or on a bench with their ankles locked between two horizontal boards. The body was relatively comfortable. The indignity was the sitting, the exposure, the public visibility. But the stocks, by the standards of medieval punishment, were considered a mild sentence. They were used for minor offenses. Drunkenness, petty disorder, the kind of infraction that required a public acknowledgement, but not a serious consequence. The pillory was different. The offender stood bent forward with both the neck and the wrists secured in a wooden frame at roughly chest height. This posture, maintained for hours, produced genuine physical strain. The back ached, the neck stiffened. The wrists, locked at an awkward angle, went from uncomfortable to painful over the course of an afternoon. And crucially, the pillory left the face exposed and forward, facing. The offender could not look away from the crowd, could not turn their back, could not avoid the gaze of every person who passed through the square that day. The pillory was specifically designed to maximize the experience of being seen. This was not incidental. It was the point, the shame was the sentence. The pillory was not reserved for bread that was slightly too light, though bread fraud was genuinely a common reason. The assize of bread, one of the oldest pieces of English consumer protection law, set strict standards for the weight and price of loaves. A baker who consistently undersold was cheating every customer who bought from him. The pillory was considered an appropriate response. But the range of offenses that could earn a pillory sentence was wide. Forestalling, which meant buying up goods before they reached the market in order to sell them at a higher price, was a pillory offense. So was regrating, which meant buying goods at market and immediately reselling them at a profit in the same market. Medieval economic regulation had a strong opinion about middlemen, and that opinion was expressed primarily through wooden frames in public squares. Fraud of various kinds earned the pillory, false weights and measures, selling goods that were not what they claimed to be. A man convicted of selling wine that had gone bad, but presenting it as fresh, could expect to find himself in the pillory with the wine poured over his head. This detail appears in multiple records. The medieval court had a gift for thematic punishment. Perjury was a pillory offense. So was spreading false rumors in some jurisdictions. The crime of being a common scold, a person who disturbed the neighborhood with persistent public argument, could also lead to the pillory, though it more commonly led to a different device entirely, which we will come to in a later hour. The common thread was that these were crimes against the community, against the shared fabric of trust that a market, a neighborhood, a town depended on. The pillory put the offender back into that community, physically, inescapably, and let the community respond. The crowd was not a passive audience. It was an active participant, and the court knew this when it sentenced someone to the pillory. The sentence was not simply stand here for 4 hours. The sentence was stand here for 4 hours while your neighbors decide what you deserve. What the crowd threw varied enormously. Rotten fruit and vegetables were common, soft enough, usually, to humiliate without seriously injuring. Mud, offal from the butcher's stalls nearby, eggs that had been kept past their moment of usefulness. But the crowd could also throw harder things, stones, bones, objects that were not soft at all. The records contain accounts of people who were blinded in the pillory, people who were struck hard enough to suffer lasting injury, people who, in documented cases, died. The court was aware of this possibility, and in cases of particularly despised offenders, it is difficult to avoid the conclusion that the court was not entirely displeased by it. The pillory for a perjurer who had caused the wrongful punishment of an innocent person, for instance, was sometimes accompanied by a notice that made the specific nature of the crime very clear to the crowd. The notice was not a neutral document. It was an invitation. The crowd, in those cases, tended to accept. The cucking stool is one of those medieval punishments that sounds, at first hearing, almost comic. A chair, on a long wooden arm, positioned over a pond or a river. The offender seated in it, then swung out over the water, then dunked. It was used, in most of its documented applications, against women, specifically against women who had been convicted of scolding, of selling bad ale, of engaging in what the records describe, with magnificent vagueness, as being a common nuisance. The chair was mounted on a pivoting beam, fixed to a post at the water's edge. The offender was strapped in. The beam was swung. The chair went out over the water, and then, depending on the sentence, the chair was lowered until the occupant was submerged. Once, twice, sometimes more, the water was cold. It was usually a public pond or a mill stream, whatever happened to be conveniently located near the town center. The crowd gathered on the bank. The ducking was a public event, scheduled in advance, announced in the same way as a market day or a fair. The number of dunkings was specified in the sentence. A first offense might earn 1 or 2. A repeat offender might earn considerably more. The records from some English towns specify the precise number with the same matter, of fact tone used to record the price of grain. The cucking stool was presented in the legal texts of the period as a corrective measure, a way of cooling a hot temper, a way of reminding a person that the community had a threshold for disruption, and that they had crossed it. The language of correction is interesting. It implies that the person being ducked was expected to emerge from the water changed, chastened, less inclined toward whatever behavior had brought them to the pond in the first place. Whether they did emerge changed is a question the records do not answer. The records note the punishment. They do not follow up. What we do know is that the cucking stool remained in use in England for several centuries. The last documented use in England appears in the historical record in the early 18th century. It was not abolished by law so much as it gradually fell out of fashion. Communities stopped using it. Courts stopped ordering it. It drifted out of the repertoire of available punishments without any formal farewell. The pond is still there in most of those towns. It has no memory of any of this. Not all public shaming was court-ordered. Some of it was organized by the community itself, without any involvement from the formal legal apparatus. And the most elaborate of these unofficial shame rituals was the practice known as riding the Skimmington. The Skimmington was a community procession. It was organized when a neighborhood decided that one of its members had violated certain social expectations so seriously that a formal response was required, but that the formal courts were either too slow, too expensive, or too indifferent to provide it. The most common triggers were a husband who was known to beat his wife, a wife who was known to dominate her husband in ways the community found transgressive, a man who had committed adultery and was perceived to have escaped consequence, or a woman who had done the same. The ritual began at night, or in the early morning, with a gathering of neighbors. They came with noise. They came with drums, with pots beaten with ladles, with horns, with anything that could produce a sustained and chaotic sound. They came sometimes with an effigy, a rough figure made of straw or rags, dressed to represent the offender. The procession moved through the streets to the offender's house. The noise was the message. The neighborhood was saying, "We see what you have done. We do not approve, and we are going to stand outside your house and make this sound until the entire street knows it too." In some versions of the ritual, an actual person was made to ride through the streets on a horse or a pole, dressed in clothes that exaggerated or mimicked the offense. A man known to be hen pecked might be made to ride facing backward, which was a posture associated with shame and reversal. A woman accused of dominating her husband might be represented by a figure holding a ladle, which was the symbol of domestic authority turned weapon. The Skimmington could last for hours. It could be repeated on subsequent nights. It could follow the offender through the streets if they tried to leave their house. It was, in its way, a form of community enforcement that operated entirely outside the law, and that the law often chose not to notice. It required no judge, no priest, no wooden frame, just neighbors and noise, and the particular medieval conviction that the community had not just the right, but the obligation to police the behavior of its own members. Rough music is the broader category into which the Skimmington falls. It is a term used by historians to describe the tradition of communal noise-making as a form of social sanction, and it was not limited to England. Across France it was known as charivari, in Germany as Katzenmusik, which translates, with admirable directness, as cat music. In Italy, in Spain, in communities across the medieval and early modern world, some version of the same practice existed. Neighbors gathered. Noise was made. The offender was identified, publicly, through sound. The targets varied by region and period. In some communities, rough music was directed primarily at widows or widowers who remarried too quickly after the death of a spouse. The community had a sense of how long grief should last, and a person who moved on before that period had elapsed was considered to have violated something. The noise was a reminder. In other communities, rough music targeted economic offenders, a landlord who raised rents unfairly, a merchant who had cheated visibly and escaped formal consequence, a neighbor who had taken more than their share of common land. The common thread, again, was community trust. The rough music was the community's voice, made audible. It was not a verdict delivered by a court. It was a verdict delivered by everyone who lived within earshot. And in a world where reputation was one of the few forms of capital available to most people, the sound of your neighbors gathered outside your door was a form of damage that no court could fully replicate. The genius of rough music, if genius is the right word, was that it required no authority to organize it. It required only consensus. If enough people agreed that something wrong had happened, and that the formal systems had failed to address it, the noise began. And once it began, it was very difficult to make it stop. You could not find the noise. You could not imprison it. You could only wait for it to decide, collectively, that it had made its point. The theory of the shame punishment was tidy. The offender stands in the square. The community expresses its disapproval. The offender absorbs the lesson. Everyone goes home. The social fabric, briefly torn, is repaired. The practice was considerably less tidy. The most obvious way shame punishments went wrong was when the crowd misjudged its own strength. What began as rotten vegetables could escalate over the course of an afternoon into something harder and less forgiving. The records contain accounts of men who entered the pillory in good health and were carried away from it with broken bones, lost eyes, or injuries that killed them within days. The court, in these cases, faced a complicated situation. The crowd had, technically, exceeded its sanctioned role. The sentence had been public humiliation, not death, and yet, prosecuting a crowd for enthusiastically performing a function the court had explicitly invited them to perform was, in practice, nearly impossible. You could not put several hundred people on trial for throwing things at the person the court had placed in front of them for that purpose. In most cases, the records simply note the outcome. The offender died. The case is closed. No further action is recorded. There were also cases where shame punishments went wrong in a different direction. Cases where the crowd refused to participate. Where the offender stood in the pillory and the square went about its business around them with something approaching indifference. No vegetables, no noise, no engagement of any kind. This was, in its way, a worse outcome for the court than the violence, because the silent crowd was sending its own message. It was saying that it did not agree with the verdict, that the community did not share the court's assessment of what had happened and what it deserved. A crowd that did not throw things at the person in the pillory was a crowd that was declining to ratify the sentence. In a justice system that depended fundamentally on community participation, that silence was a form of acquittal the court had no mechanism to override. Most people who were sentenced to the pillory survived it. The experience was painful and humiliating and long, but most walked away from it at the end of the day. And the question of how they managed that practically is worth a moment. The first thing the condemned needed was allies. Friends or family members who could position themselves near the pillory and, without being too obvious about it, deflect the worst of what the crowd threw. Who could ensure that the water they were given to drink was clean? Who could speak quietly to them during lulls in the crowd's attention? Who could be there, physically, at the end of the day when the frame was unlocked and the person needed to be helped upright and walked home? The physical aftermath of a day in the pillory was not trivial. The neck and back, held in a bent position for hours, took time to recover. The hands, locked at an awkward angle, were often numb or swollen. If the crowd had been active, there were bruises or worse. The psychological aftermath is harder to document. The records do not ask how people felt, but the social reality of returning to a community that had just spent a day expressing its collective opinion of you, through whatever came to hand, was not something that resolved quickly. Some people left, moved to other towns, started again somewhere that did not know their name or their crime. Others stayed, and the records suggest that in many cases the community, having delivered its verdict through the pillory, considered the matter settled. The punishment had been performed, the shame had been absorbed, the social account, as the medieval world understood it, had been balanced. You had stood in the square. You had received what the court and the community had decided you deserved. And now it was done. That is, in its strange way, a form of closure that modern justice systems spend considerable effort trying to replicate. Medieval towns did not have prisons in the modern sense. They had holding cells, small rooms beneath a courthouse or a gatehouse, used to keep accused persons until their trial. They were not designed for long-term occupation. They were cold, dark, often shared with other prisoners, and with whatever wildlife had found its way in. They were, by any reasonable standard, dreadful. But the deeper reason communities preferred shame punishments to imprisonment was not logistical. It was philosophical. Prison removes a person from the community. It places them somewhere separate, somewhere out of sight, where the community does not have to look at them or think about them. The punishment happens in private. The community is not involved. The community does not get to speak. The pillory, the cucking stool, the stocks, the rough music, all of these kept the punishment inside the community. They required the community to be present, to witness, to participate. They treated justice as something that happened between people who knew each other, in a space they all shared, in a process that everyone could see and verify. This was not simply about spectacle. It was about accountability. In a world without written records that most people could access or understand, The community's collective memory was the record. If 1,200 people watched Thomas the baker stand in the pillory on a Tuesday morning in autumn, then 1,200 people knew what Thomas had done and what had been done about it. That knowledge did not need to be filed or archived. It lived in the people who had been there. Thomas the baker went home that evening, stiff, bruised, smelling of whatever the market square had chosen to express itself with that afternoon. His neighbors passed him on the narrow street without quite meeting his eyes, but the next morning his oven was lit. The loaves went in, and when the bread came out, it was the right weight. It stayed the right weight. The market court did not see Thomas again. Whether that was shame or fear or something more complicated, the records do not say. But the pillory had done what it was designed to do. It had held a person up inside the community that would have to continue living with them, and asked that community to respond. And the community had, and then it had moved on. That is a rougher justice than what we have now, but it is not, perhaps, a less human one. Public shame as punishment assumes something that modern justice systems have largely stepped away from. It assumes that the opinion of your neighbors matters, that being seen and judged and made to stand in the place where everyone you know can look at you constitutes a genuine consequence. We have decided largely that it does not. That justice should be administered at a distance by strangers, in rooms the public cannot easily enter. We have good reasons for that decision. The crowd that threw stones was not always right. The community that organized rough music was not always just. But something was also lost, the directness of it, the visibility. The fact that the punishment happened in the same square where the harm had occurred, in front of the same people who had been harmed. In those cold market mornings, justice was something everyone could see, even if what they saw was not always something to be proud of. And we will leave Thomas there in the gray autumn light, walking home, and drift now somewhere else entirely. Picture this, a market lane in a mid-size English town. A Tuesday, because it is always a Tuesday in a medieval market town. The year is somewhere near 1280. A cart is moving through the crowd. It is loaded with grain sacks, stacked high, heavier than they should be for the width of the lane. The wheel catches a rut in the cobblestones. The cart lurches. One of the grain sacks shifts. And then the whole load tips, slowly and then all at once. And a child who is standing in exactly the wrong place, at exactly the wrong moment, is struck and killed. The carter did not intend it. The crowd saw it happen and knew he did not intend it. By any reasonable assessment of the event, it was an accident. A terrible, ordinary, medieval accident, but the cart was not innocent. In the eyes of the law, the cart had caused a death. And in the law of medieval England, a thing that caused a death could be found guilty. It could be seized. It could be forfeited. It could be made, in the formal language of the courts, to pay for what it had done. This is the Deodand, and it is one of the strangest legal doctrines in the history of English law. The lane is quieter now. The crowd has pulled back from the cart, the way crowds pull back from things that have just gone wrong. The grain is scattered across the cobblestones. The horse is standing still, confused by the stillness around it. Someone has covered the child. The carter is sitting on the ground nearby. He is not being restrained. Nobody is accusing him of anything, exactly. But nobody is helping him restack the grain either. There is a particular quality of suspension that settles over a space where something terrible has just happened, before the formal response has arrived to tell everyone what to do next. What arrives, eventually, is the coroner. In medieval England, the coroner was not primarily a medical examiner. He was a royal officer. His job was to attend sudden or unexplained deaths, and to determine, on behalf of the Crown, what had caused them and what, if anything, the Crown was entitled to as a result. He will look at the cart, He will look at the grain sacks, he will look at the wheel that caught the rut, and he will make a determination. The cart is worth perhaps a few shillings. The grain now scattered was worth more before it hit the ground. The horse is worth considerably more than either. The question is which of these things caused the death, because whatever caused the death belongs now to God. And what belongs to God, in practical terms, belongs to the crown, the Deod, and was not a punishment for the carter. He was not on trial. His intent was not the court's concern, the medieval law of the Deod, and was not interested in blame in the way we understand blame. It was interested in cause, the thing that moved, the thing that struck, the thing that, by its motion, had ended a life. That thing was guilty. And the real question was how much it was worth. The word Deod, and comes from the Latin Deodandum, meaning that which must be given to God. It was a legal doctrine embedded in English common law from at least the 12th century, and possibly earlier. Its origins are genuinely difficult to trace with precision. Some historians find roots in Anglo-Saxon law. Others see the influence of older Roman legal thinking about objects that had caused harm. The principle at its core was this: if a moving object caused the death of a human being, that object was forfeit. It was seized by the coroner, assessed for its value, and that value was paid, in theory, to the church for prayers for the soul of the deceased. In practice, the value went to the crown, or to the local lord who held the relevant rights, with the church receiving whatever portion the powerful parties felt was appropriate. The key word in the doctrine was moving, a Deod, and had to have been in motion at the moment of the death. A stationary object could not be a Deod, and if a person tripped over a fence post and died, the fence post was not forfeit. The fence post was not moving. The fence post had not done anything. But if a wheel had turned, if a millstone had ground, if a boat had drifted, and a person had died in contact with that motion, the moving thing was the Deod, and this distinction between moving and stationary objects is the most revealing aspect of the doctrine. It suggests that what the medieval legal mind was grappling with was something like moral agency, not in the full sense. Not in the sense that the cart had intentions, but in the sense that the cart had, through its movement, participated in the event. It had been, in some sense, the active party, the logic of the Deod, and is not, on reflection, entirely alien. We still, in ways we do not always examine, attribute a kind of agency to objects. A gun that kills someone is treated differently, in both law and public feeling, than a gun that never fires. A car that strikes a pedestrian becomes, in the immediate aftermath of the accident, something that people look at differently than they did before. We know rationally that objects do not have intentions, but something in human cognition resists the clean separation of the instrument from the act. The Deod, and was the medieval legal system formalizing that resistance. There was also a theological layer. The medieval church held that God was present in all events, that nothing happened by pure accident, that a child killed by a cart was a child whose death had occurred within God's creation, under God's watch, through an instrument that God had, in some sense, permitted to be the instrument of that death. The Deod, and in this view, was a form of acknowledgement. It said that the death had occurred, that something had caused it, that the community recognized the weight of that fact, and that it was, in the formal and legal sense, giving something to God in recognition of it. It was grief expressed as property law, which is, in its way, a very medieval solution to a very human problem. The coroner's inquest into a Deod, and death was a formal legal proceeding. It required a jury. Not the same jury as a criminal trial, but a local jury of men who had witnessed the event, or who lived near enough to have reliable knowledge of it. The jury was asked to answer a specific set of questions. Was there a death? Was the death sudden or unexplained? What was the instrument of the death? Was that instrument in motion at the time? What was its value? The value assessment was taken seriously. The coroner and jury were expected to examine the object, assess its condition, and arrive at a fair market valuation. A cart in good repair was worth more than a cart in poor repair. A horse was assessed by age, condition, and breed. A millstone was assessed by size and quality. The valuation mattered because it determined how much the crown or the lord would receive, and because it determined, in some indirect sense, the weight the community assigned to the death. A high valuation was a form of acknowledgement that what had happened was serious. A low valuation was, perhaps, a community's quiet editorial on how much they felt the formal machinery needed to involve itself. The records of Deodand and inquests are among the more unusual documents in medieval English legal history. They are full of careful, specific, almost tender assessments of objects. The wheel of a cart described in detail. The condition of a rope that broke and let a man fall. The weight and speed of a millstone at the moment it claimed someone's hand. It is a remarkable archive. A record of all the ways the ordinary machinery of medieval life went wrong, assessed with the careful attention of people who were trying to make sense of loss through the only language available to them, which was, in this case, the language of property and law. The Deodand and records are, among other things, a remarkable inventory of medieval technology and the ways it failed. Carts appear frequently. They were everywhere in medieval life, constantly moving through streets and lanes that were not always designed to accommodate them, pulled by animals that did not always cooperate, loaded by people who were not always careful. When they went wrong in very public ways. The records note carts that overturned, carts whose wheels broke, carts that rolled when they should have stayed still. Millstones appear with some regularity. A millstone in motion was a genuinely dangerous object. Heavy, fast, turning, unforgiving of any hand or foot that came too close. The miller's trade was one of the more physically hazardous occupations of the medieval world. The Deodand and records reflect this. Boats were found guilty. A boat that drifted and struck a person, or that capsized and drowned its occupants, could be assessed as a Deodand. The river was a working space in medieval England, full of ferries and fishing vessels, and the slow movement of goods between towns. When someone drowned, the boat, if it had been in motion, was the Deodand, and there are records of ladders, of trees that fell, of barrels that rolled. One record notes a brewing vat, a large wooden vessel used in the making of ale, which had somehow become the instrument of a death, and was accordingly assessed and forfeited. There is something quietly remarkable about reading these records. Each entry is a death. Each death has an object, and each object is described with the same careful, neutral language, whether it is a horse or a millstone or a brewing vat. The law did not distinguish between them on the basis of dignity or importance. A death caused by a barrel was treated with the same procedural seriousness as a death caused by a cart. That consistency is, in its way, a form of respect. Every death warranted the same formal attention. Every object that had caused one warranted the same careful assessment. The medieval legal mind was, in this respect, more even-handed than it is sometimes given credit for. Once the inquest had assessed the Deodand and assigned it a value, the object itself had to be dealt with, and what happened to it varied in practice considerably. The most straightforward outcome was forfeiture. The object was seized by the relevant authority, the crown, the local lord, or their representative, and either kept, sold, or disposed of. A cart in good condition might be sold at market. A horse might be put to work. A millstone might be resituated at another mill. The object passed out of its owner's hands and into the possession of whoever held the Deod, and rights in that jurisdiction. This was, for the owner of the object, a significant secondary loss. The cart that had killed someone was not just the instrument of a tragedy. It was also, now, confiscated property. The farmer who owned it had lost both the peace of his conscience and a significant piece of working equipment. In some cases, the owner could pay a redemption fee, a sum assessed by the coroner that allowed them to buy the object back from the authority that had seized it. This arrangement appears frequently in the records, suggesting that it was common practice for owners who could afford it to redeem their Deod, and rather than lose them entirely. The Crown received the money, the owner kept the cart. The legal requirement of forfeiture was satisfied by the payment of its assessed value. For owners who could not afford the redemption fee, the loss was absolute. The cart was gone, the millstone was gone. The boat was gone. On top of whatever grief they carried for the person who had died, they now carried the practical weight of lost equipment in a world where equipment was expensive and not easily replaced. There is no record of anyone complaining about this publicly. Complaint was not, in most circumstances, a productive response to a legal determination in the medieval world. But the records of redemption fees suggest that people acted, where they could, to limit their losses, which is, perhaps, complaint expressed through the only available channel. The formal answer to this question was the Church. The Deod, and was Deodandum given to God, and God's earthly representatives were the Church. The money was supposed to pay for prayers for the soul of the deceased. Masses said, candles lit, the formal machinery of medieval intercession set in motion on behalf of the person who had died. The practical answer was more complicated. By the 13th and 14th centuries, the rights to Deod, and in most English jurisdictions, had been granted by the Crown to local lords as part of the broader system of manorial privileges. A lord who held Deod and rights in his manor was entitled to receive the value of any Deod, and that occurred within it. He was, technically, supposed to ensure that prayers were said and that the Church received its appropriate portion. In practice, the money went into the Lord's accounts, and the oversight of what happened next was limited. The Crown itself held Deod, and rights in royal forests, and in areas not covered by manorial grants. Royal records from the 13th and 14th centuries contain numerous Deod, and assessments carefully noted by royal officials with the same attention to detail as any other form of revenue, because that is, in the end, what the Deod and became revenue, a form of income derived from the accidents of medieval life. The theology remained. The prayers were still nominally the purpose, but the system that administered it was a system for extracting value from misfortune, and the people who administered it were not primarily motivated by the welfare of the dead. This is not surprising. Medieval institutions, like all institutions, tended over time toward the interests of the people who ran them. The Deod and began as a theological gesture toward the weight of accidental death. It ended, several centuries later, as a line item in an estate account, which is, perhaps, also a very medieval story. And also, now that you think about it, not entirely an unfamiliar one. Animals occupied a complicated position in the Deod and system. They were objects in the legal sense. They were property. They could be assessed and forfeited like any other piece of equipment. But they were also, obviously, living things with some capacity for independent action. And this created a set of questions the medieval legal mind found genuinely difficult to resolve. A horse that kicked a person to death was a relatively straightforward case. The horse had moved, the horse had struck, the horse was the Deod, and it was assessed, forfeited, and the matter was recorded. But a horse that threw its rider, who then died of the fall, raised harder questions. Was the horse the Deod? or was the fall itself the instrument of death? If the rider had struck a stone in falling, was the stone the Deod? And the stone had not been moving, but the rider had struck it with considerable force. The records show coroners wrestling with exactly these kinds of distinctions. Different inquests reached different conclusions on similar facts, the law of the Deod, and was not a precisely codified system. It was a principle applied by local officials using their best judgment, and local officials varied considerably in both their legal knowledge and their interpretive instincts. What the animal cases reveal more than anything is the fundamental ambiguity at the heart of the doctrine. The Deod, and was supposed to identify the moving cause of a death. But cause, in a world without the conceptual tools of modern physics or forensic science, was genuinely difficult to assign with precision. Was the horse the cause, or was the road? Was the millstone the cause, or was the miller who set it turning? Was the cart the cause, or was the rut in the cobblestones that caught the wheel? The coroner made a decision. The jury ratified it. The Lord received the money, and the question of what had truly caused the death remained, as it so often does, more complicated than the official record acknowledged. One documented case from the 14th century involves an ox. The ox had been pulling a plow when it stumbled, falling onto a farmhand who was working nearby. The farmhand died. The coroner assessed the ox as the Deod, and the ox was forfeited. The farmer, who had now lost both a worker and a working animal in a single morning, apparently paid the redemption fee to get the ox back. The ox, for its part, returned to plowing, unaware of its brief legal status as a guilty party, which is, honestly, the correct response to most legal proceedings. The Deod and system was, from its earliest days, vulnerable to a particular kind of institutional appetite. The doctrine said that moving objects that caused death were forfeit. It did not say that the moving objects had to be small ones. By the 16th and 17th centuries, the Crown had begun to apply the Deod and doctrine to ships. A ship that had caused a death at sea, or in a harbor, or on a river, could be assessed as a Deod, and ships were not worth a few shillings. Ships were worth very large sums indeed. The application of the Deod and to ships created a situation that the doctrine's original designers had certainly not anticipated. A merchant vessel worth thousands of pounds, crewed by dozens of men, operating under a complex web of ownership and charter arrangements, was now potentially subject to forfeiture because a sailor had died aboard it in circumstances that could be attributed to the ship's motion. The legal arguments that surrounded ship Deodans were elaborate and prolonged. Ship owners were not inclined to simply accept the forfeiture of vessels worth small fortunes. They hired lawyers. They argued about jurisdiction, about the definition of motion, about the chain of causation between a ship's movement and a specific death aboard it. The Crown, equally, was not inclined to give up a revenue source of that magnitude. Royal officials pursued ship Deod and claims with considerable energy. The result was a body of legal argument that grew increasingly strained. By the early 19th century, the Deod, and was being applied to railway locomotives. A locomotive that struck and killed a person on the tracks was assessed as a Deod, and the first recorded railway Deod, and in England dates from 1833. The locomotive was assessed, the railway company paid, but locomotives were not brewing vats. They were not ox carts. They were machines worth enormous sums, operating in an industrial economy that had no patience for a medieval legal doctrine that threatened to impose unpredictable forfeitures on every accident. Involving heavy machinery, the pressure on Parliament to abolish the Deod, and became, in the 1840s, very difficult to resist. The Deodand's Act of 1846 did not abolish the doctrine on philosophical grounds. It did not declare that objects could not be guilty, or that the theological logic of the Deodand was unsound. It abolished it because the railways needed it abolished. The language of the act was practical. The Deodand and was causing uncertainty and difficulty in the administration of industrial accidents. It was creating inconsistent outcomes. It was, in the careful language of parliamentary debate, no longer fit for purpose. And so, after approximately 700 years of English legal practice, the doctrine ended, quietly, by Act of Parliament, in the same matter of fact way that most very old things end, not with a grand philosophical repudiation, but with a committee deciding that the paperwork had become more trouble than it was worth. The ox carts were gone by then anyway. The millstones were giving way to mechanized grinding. The world that had produced the Deodand, and the world of local coroners and manorial lords and grain sacks tipping off carts in market lanes, had already largely disappeared. The doctrine outlasted it by just enough years to cause serious problems for the railway industry, which is, if you are looking for a final assessment of its character, perhaps the most medieval thing about it. The Deodand and persisted for 700 years because it answered a need that has not, in truth, gone away. The need to point at the thing that caused the harm, to name it, to hold it formally and publicly accountable. We do not forfeit locomotives any more. We do not assess the value of carts and present the sum to a lord in lieu of prayers. But we still, in product liability law and safety regulation, and the long aftermath of industrial accidents, ask the same essential question the medieval coroner asked standing in a market lane. Beside a spilled cart, what moved, what caused this, and who or what must answer for it? The language has changed. The theology has gone. But the impulse is the same impulse that sent a coroner to kneel beside a grain sack in 1280 and say, formally, on behalf of the community, that this death had weight, and that weight required a response. There is something unexpectedly tender about the Deodand, and when you sit with it long enough, it was a clumsy doctrine. It was exploited. It became, over centuries, more about revenue than about grief. But at its origin, it was a community's attempt to say that accidents were not nothing, that a child struck by a cart in a market lane deserved more than a shrug and a return to business, that the instrument of a death was connected to that death in a way that the law should acknowledge. We have better tools now, safer machinery, liability frameworks that reach further and more precisely than any medieval coroner could manage. And yet accidents still happen, and the impulse to point at the thing that caused them, and to say, formally, that it bears some responsibility, is still very much with us. The ox knows nothing of this. The ox went back to ploughing, but somewhere in the records of a 14th century English manor, it is still listed, assessed, guilty, redeemed, and the farmhand is remembered in that dry legal language, because the law required something to be said about his death. That is not nothing even now. Her name was Margaret, and in the year 1593, in a market town in the north of England, she said something. The records do not preserve what she said. They preserve only the fact of it, that she had spoken, in public, in a manner that the court described as troublesome and contentious. That her neighbors had complained, that the complaints had accumulated over time, until the weight of them was sufficient to bring the matter before the magistrate, and that the magistrate had ordered the fitting of the scold's bridle. The bridle was an iron device. It enclosed the head, it silenced the tongue, and Margaret would wear it through the streets of her town, led on a chain while her neighbors watched. This is the world of the scold's bridle, and it is one of the most uncomfortable corners of medieval and early modern law. The morning of the fitting is cold and gray, the kind of gray that northern English winters specialize in, the kind that settles into the stones of the buildings and stays there until April. Margaret is brought to the place where the bridle is kept. It is a town bridle owned by the municipality, available for use by the court as needed. It is made of iron. It fits over the head like a cage, with bands that run across the crown and down the sides of the face, meeting at the chin. At the front, where the mouth is, there is a flat plate of iron, or in some versions a shaped protrusion, a bit, designed to press down on the tongue when the mouth closes. The bridle is locked at the back of the head, a chain is attached to the front, and then Margaret is led out into the street. The walking itself is the punishment, the being seen, the being led, the iron on her face, the inability to speak, which is the specific, targeted, deliberate point of the device. The town watches. Some faces are curious, some are uncomfortable. Most probably arrange themselves into the expression of people who have decided not to have an opinion about what they are watching. It is cold, the iron is cold, the chain is cold, and Margaret is silent. The scold's bridle was not designed to injure. It was designed to humiliate, to demonstrate, physically and publicly, that the community had the power to silence a voice it found troublesome. But the bridle could injure, the bit pressed on the tongue. If the wearer stumbled or was pulled forward too sharply by the chain, the pressure on the tongue increased. There are accounts, though not many, of tongues lacerated by the bit during the procession. The device was not precise. It was made by blacksmiths to a general pattern, not by surgeons to an individual fit, and the consequences of an imperfect fit were borne entirely by the person wearing it. And the question underneath all of this, the question worth sitting with, is what exactly Margaret had said. The scold's bridle, also known in some regions as the branks, was an iron head cage used as a punishment device in Scotland and England from roughly the 16th century onward. It appears in the historical record somewhat later than the pillory or the cucking stool, and it was never a nationally standardized instrument. Different towns owned different versions. Different blacksmiths made them to different specifications. The basic structure was consistent: iron bands forming a cage around the head, a locking mechanism at the back, a projecting piece at the mouth, the bit or the gag, designed to prevent speech by pressing on the tongue or the roof of the mouth. Some versions were more elaborate. Some bits had small spikes on them, so that any attempt to move the tongue against the plate would cause pain. These versions are documented, though whether they were commonly used or represent the more extreme end of a wide range of practice is difficult to determine from the records alone. The bridle was a municipal object in most towns that owned one. It belonged to the court, stored somewhere accessible, brought out when the sentence required it. It was not a device that individual households owned or used privately. It was a public instrument used publicly in a public process. Several surviving examples exist in museum collections across England and Scotland. They are small objects, heavier than they look in photographs. The iron has the particular quality of very old iron, dark and dense and cold to the touch, even on a warm day. They are difficult to look at for very long. The crime of scolding had a formal legal definition, and that definition is worth examining carefully, because it is both narrower and wider than it first appears. A scold, in the legal language of the period, was a person who was a common disturber of the peace. Not someone who had an argument once, not someone who raised their voice in a single dispute. The legal standard required that the behavior be habitual, repeated, known to the neighborhood. The formal Latin term used in some records was communis rexatrix, for a woman, or communis rexator, for a man, meaning a common brawler or quarreler. The distinction between the male and female forms is significant, because the crime, while technically applicable to both, was prosecuted almost exclusively against women. The behaviors that attracted the label were varied. A woman who argued persistently with her husband in a way audible to neighbors. A woman who disputed loudly with tradespeople in the market. A woman who had a running public conflict with another household and was perceived as the aggressor in that conflict. A woman who spoke critically of local officials or of the management of community affairs. That last category is the one that sits most uncomfortably in the historical record, because a woman who complained about how the town was run was, under some applications of the scolding law, a woman who could be bridled for it. The line between a common disturber of the peace and a person with a legitimate grievance, expressed loudly, was not drawn by the person speaking. It was drawn by the people listening, and the people listening were, in almost every documented case, men. The profile of the accused scold, across the documented cases, is consistent enough to suggest a pattern. She was, in most cases, older. The records skew toward women in their 30s, 40s, and 50s, rather than younger women. This may reflect the fact that older women had more accumulated grievances to express, or more confidence in expressing them, or less social protection against the consequences of doing so. She was, in most cases, of middling or lower social rank. Gentle women were not bridled. The bridle was a punishment for women who did not have the social standing to make the application of it embarrassing to the court. A woman with powerful male relatives, a husband of substance, a father with influence, was unlikely to find herself in front of a magistrate on a scolding charge, regardless of how loudly she spoke. She was, in many cases, a widow, or a woman whose husband was absent or ineffectual, or had himself been in conflict with the community in ways that had left the family without reliable male protection. The scolding law operated, in practice, as a mechanism for managing women who were perceived to be operating outside the normal structures of male oversight. This is not a subtle observation. The historical record makes it fairly plain. The crime of scolding was, at its core, a crime of speech that was considered inappropriate because of who was doing the speaking. A man who argued loudly and persistently with his neighbors was difficult. A woman who did the same thing was potentially a scold. The bridle did not care about the content of the speech. It cared about the fact of it. And the fact of a woman's voice, raised and repeated in public, was, in this period and in these communities, something that certain men in certain positions of authority found intolerable enough to silence with iron. The scold's bridle was not a single standardized object. It was a category of object, and within that category there was considerable variation, reflecting the different blacksmiths who made them, the different towns that owned them, and the different periods in which they were produced. The basic cage structure was consistent. Bands of iron running over the crown of the head, down the sides of the face and under the chin, meeting at a locking point at the back. The bands were riveted at their intersections. The whole assembly was rigid. It did not flex or bend once fitted. It sat on the head with the particular immovability of iron that has been shaped specifically to enclose something. The bit varied significantly. In the simplest versions, it was a flat plate of iron that pressed against the tongue when the mouth was closed. The pressure was not extreme in these versions, uncomfortable, constant, but not sharp. In more elaborate versions, the bit had a raised central ridge. Pressing the tongue against the ridge produced a more focused discomfort. In the versions with small spikes on the upper surface of the bit, any movement of the tongue against the plate produced pain. These versions appear in the record less frequently, and some historians have suggested that they were used primarily for repeat offenders, or for cases in which the court wanted to signal particular severity. The outer surface of some bridles carried additional features, a ring at the front, through which a chain could be passed for leading the wearer through the streets. In some examples, a small bell attached to the top of the cage, so that the wearer announced their own presence with every step. The bell was not universal, but where it appears in the records, the intent is clear. The punishment was not only to silence. It was to replace the wearer's own voice with a sound they could not control and could not stop. The surviving examples in museum collections show considerable wear. The locking mechanisms are stiff with age. The bits are polished in the places where they made contact, polished by the pressure of tongues pressing against them across decades of use. That detail, the polish on the bit, is the kind of detail that takes a moment to absorb. These were not display objects. They were used repeatedly by towns that kept them in storage between sentences, ready for the next time the court decided that someone's voice required iron management. The sentence of the bridle was, in most documented cases, measured in hours rather than days. Unlike the ordeal, which required a 3-day waiting period, or the pillory, which ran from morning to evening, the bridal procession was typically shorter. An hour, 2 hours, enough time to walk through the main streets of the town and be seen by the people who needed to see. The walking was mandatory. The bridle worn in a private room would have been pointless. The punishment required an audience. The sentence was, in its practical form, a guided tour of the town's public spaces, conducted in iron at the pace of the person holding the chain. In some cases, the chain was held by a town official, a constable or an officer of the court. In other cases, it was held by the woman's husband. This latter arrangement appears in the records with a frequency that is difficult to interpret charitably. A husband leading his wife through the streets on a chain attached to an iron cage fitted over her head was simultaneously the instrument of her punishment and the primary beneficiary of the court's intervention in their domestic situation. The records do not note how this felt to anyone involved. They note only that it occurred. After the procession, the bridle was removed. The woman was returned to her household. The sentence was considered served. There was no formal period of recovery, no acknowledgement that wearing an iron cage on the head for 2 hours in a cold northern town might have physical consequences worth attending to. The court's involvement ended with the removal of the device. What happened next was private, and the law had no further interest in it. The procession was the punishment in the same way that the pillory was the punishment. The physical device was the instrument. The public nature of the event was the point. The route was not random. The court, or the constable who administered the sentence, chose the path through the town with some care. It passed through the market. It passed through the streets where the accused was known. It passed, in most cases, by the households of the people who had made the original complaint. This last detail is worth noting. The procession was not simply a display of punishment to the general public. It was, in part, a delivery of the punishment to the specific people who had requested it. The neighbors who had complained to the court were able to watch the result of their complaint walk past their doors. Whether this produced satisfaction or discomfort or some complicated mixture of the two, the records do not say. Human responses to getting what they asked for are rarely as straightforward as the asking suggests. The crowd that gathered to watch the procession was, in most accounts, quieter than the crowd at the pillory. The pillory invited active participation. The bridal procession did not. The woman in the bridle could not respond to anything thrown at her, could not speak, could not argue. The interaction was entirely one, directional. The crowd watched, the woman walked, the chain led. Some accounts note that the procession attracted children, who followed at a distance with the particular fascination that children have for things that are strange and slightly frightening. Some accounts note that women watching from doorways or upper windows looked away. The silence of the crowd at a bridal procession was a different kind of silence than the silence of a crowd that had decided not to throw things at the person in the pillory. It was not a silence of dissent. It was a silence of something harder to name. The particular quiet that settles over a public space when something is happening that everyone present understands on some level to be wrong, but that no one has the standing or the language to say so. That silence has its own weight. It always has. The scold's bridle was, in the overwhelming majority of its documented uses, applied to women, but the records contain a smaller, quieter category of cases in which men were also subjected to it. And those cases are worth examining, because they complicate the simple narrative that the bridle was purely a gendered instrument. Men were bridled in the documented cases for a narrower range of offenses than women. The most common was persistent public blasphemy. A man who repeatedly and publicly cursed in ways that the community found intolerable could, in some jurisdictions, be sentenced to the bridle. The logic was the same logic applied to women. The voice was the problem. The iron was the solution. There are also records of men being bridled for what the courts described as false and seditious speech, spreading rumors that undermined public order, making accusations against local officials that were deemed to be unfounded and malicious. In these cases, the bridle was used not primarily as a gendered punishment, but as a tool for managing speech that the authorities found politically inconvenient. This is a distinction that matters. When a woman was bridled for scolding, the court's concern was, at its core, with the fact that she was speaking persistently in public. When a man was bridled for seditious speech, the court's concern was with the specific content of what he was saying. The woman's voice was the problem. The man's words were the problem. The device was the same. The reasoning was different. And that difference tells us something important about how the period understood the relationship between gender, speech, and authority. A man with a persistent public voice was a man saying the wrong things. A woman with a persistent public voice was, in the court's assessment, simply a woman with a persistent public voice. The wrongness was not in the content. It was in the speaking itself. That asymmetry did not go entirely unnoticed at the time. There are records of local disputes about bridal sentences for women that suggest not everyone in a given community agreed that the punishment was appropriate. Husbands who refused to lead the chain, neighbors who declined to watch, magistrates in later periods who expressed reluctance to order the device. The dissent was quiet. It did not produce reform, but it was there, in the record, if you look for it. The scold's bridle did not end by Act of Parliament, unlike the Deodand, and which was formally abolished in 1846. The bridle simply stopped being used. It drifted out of practice across the 17th and 18th centuries, gradually, unevenly, without any central decision or formal farewell. The last documented use in England is generally placed in the early 18th century. The last in Scotland, somewhat later. The dates are approximate. The records become sparse before they disappear entirely, which is itself a form of evidence. Courts that were using the bridle regularly kept records of its use. Courts that had stopped using it left no record of having stopped, because there was nothing to record. The reasons for its disappearance are several, and none of them is particularly satisfying as a story of moral progress. Changing ideas about public punishment played a role. The 18th century saw a broader shift away from shaming punishments and toward incarceration as the preferred mode of correction. The pillory was formally abolished in England in 1837. The stocks fell out of use around the same period. The bridle preceded both of these in its disappearance, but it was part of the same general movement away from public bodily punishment as the primary instrument of social control. Changing ideas about women's speech also played a role, though more slowly and unevenly than we might hope. The category of the scold, the legal construct of the persistently speaking woman as a public nuisance, did not disappear quickly. It lingered in the language and in the social attitudes that had produced it long after the iron device was gone. What disappeared first was the willingness to use the physical instrument. The attitude that had justified it took considerably longer to follow. The scold's bridle is among the strange punishments of the medieval and early modern world, the one that is hardest to hold at a comfortable historical distance. The ordeal feels alien, the Deod, and feels academic. The pillory feels, at least, like a practice with a comprehensible internal logic, however brutal its execution. The bridle is different because the bridle was not a response to a specific harmful act. It was a response to a voice, to the fact of persistent, public, female speech. And the response was to enclose that voice in iron and lead it through the streets on a chain. That is not a complicated message. It is a very clear one, and the clarity of it is what makes the bridle sit differently in the historical record than the other punishments we have visited tonight. The medieval world had many instruments for managing behavior it found threatening. What is revealing about the bridle is what it identifies as threatening. Not violence, not fraud, not the disruption of trade or the corruption of justice. A voice. A woman's voice, raised in public, sustained over time, unwilling to be quiet when the community decided it should be. The bridle said that such a voice was a crime, that it required a physical response, that the response should be public, visible, and conducted in iron. We do not use the bridle anymore. The iron is in museums. The chain is gone. But the impulse that produced it, the discomfort with certain voices in certain spaces, the desire to have them managed, contained, or simply made to stop, that impulse did not go into the museum. With the iron, it changed its instruments as impulses do. Margaret walked home that day. The bridle was removed. The iron was cold, and then it was gone, and her face was her own again. Whatever she had said in the market, in the street, in whatever argument had accumulated over whatever weeks or months into a court complaint, she had said it. It was said. The iron had not unsaid it. The records do not tell us what Margaret did next, whether she was quieter after, whether she was not, whether the neighbors who had complained found that the bridle had resolved whatever had troubled them, or whether they discovered, as people often do when they silence something forcibly, that the silence was less comfortable than they had expected. What the record tells us is that Margaret existed, that she spoke, that the community found her speech significant enough to address with iron, and that she survived it. That is a quieter kind of triumph than the ones history usually celebrates, but it is a triumph nonetheless. We have wandered tonight through some of the stranger rooms of medieval justice, through the fire and water of the ordeal, through the market squares of public shame, through the dry legal language of guilty objects, and now here, at the end, through the iron silence of bridle. What connects them across their differences is the question underneath each one. How does a community decide what it cannot tolerate? How does it respond to what threatens the fabric it depends on? And who gets to make that decision, and who bears the cost of it? The medieval world answered those questions with the instruments it had: iron, water, wood, fire, the voice of the crowd. The silence of the chain, we answer them with different instruments, courts with different procedures, prisons instead of pillories, legislation instead of rough music. The instruments are better in most ways, more precise, less immediately cruel, but the questions are the same questions. They have always been the same questions. And the answers have always depended, as they depended in every market square and church door and cold northern street we have visited tonight, on who is in the room when the deciding happens. That is worth remembering, quietly, in the dark. Sleep well, quiet listener, and we will meet again in another long, quiet hour.